My name is Weslen Lakins. I'm an attorney. Um, and these days, I would say that about 50% of my practice is encompasses cybersecurity, privacy law, contracts, kind of stuff, all the things that are relevant to kind of what we're talking about here today. I'm with Lewis Thomas and PC, based here in Knoxville, and we have a little over 130 attorneys across Tennessee with offices in Memphis, Nashville, Sevierville, and right here in Knoxville. Um, our firm handles a lot of data breach response, regulatory compliance, and class action litigation, primarily on the defense side of things. So today's talk is titled Liability, Landmines, and that's for a good reason. The modern cybersecurity landscape is quite literally littered with them. Uh, so, um, what does this really mean, though? Every mispatch is every unencrypted database, every mismanaged vendor contract is potential legal exposure, and because also that security isn't just about keeping attackers out. It's about proving everything that you did, everything that you reasonably could, that you did everything you reasonably could do to prevent them from getting in. And then lastly, because whenever a breach happens, everything gets scrutinized, and that's your policies, your response times, your communications, your logs, anything you can think about. Um, so let's go ahead. Ah, So it wouldn't be a legal presentation without a good old legal disclaimer first. So blame modern society for that. Seriously, though, everything I'm about to say, it's an informational only, and it should not be taken as specific legal advice. I'm not your lawyer. We do not have an attorney-client relationship, and keep in mind that some of this stuff is state-specific. So just always be wary of that. All right. So first, we're going to walk through a few case studies and looking at some high-profile breaches and incidents that illustrate just how security failures can kind of turn into a legal crisis. Um, and we won't just focus on the big names either. I tried to include some lesser-known breaches that didn't make national headlines. But then we're going to move on to break down the most common failure points that lead to legal exposure, and this is where we're going to shift from specific incidents to patterns, uh, and kind of what are the common threads running through these breaches. Finally, we're going to move on to best practices and mitigation strategies. Uh, and in that, we're going to talk about the most common failure points and kind of shift gears and talk strategy, because knowing where companies go wrong isn't always enough, and avoiding those mistakes takes proactive measures. And then we're going to have a little bit of bonus material that's got a few things that I see come up a lot here recently, specifically with cyber insurance, or trying to, I guess, outsource their liability or responsibility for data security, but along with some interesting trends in actual data breach lawsuits that I've noticed kind of pop up recently uh, as more and more come about. But finally, then we'll go through some key takeaways, just to wrap up all the lessons from today. And so that's kind of the roadmap. We're going to start with these cautionary tales and case studies, and then go on to look at patterns that emerge from those incidents. I'm sorry about that. The transition to Then transition to practical steps companies can take to mitigate those risks, um, and then finally go into those bonus materials that I was talking about. All right. So first, we're going to go through these case studies, and I honestly think these are the most important thing that you can have, is like learning from other people's mistakes. That it's really important to kind of grasp that security isn't just an IT problem anymore. It's a corporate liability issue. It can quite literally and does bankrupt many companies, small businesses included. Um, so that's, I guess, an interesting statistic here in 2024. IBM reported that the average global cost of a breach which this does also include all the major breaches, but is right at about 4.88 million. And that does, like I said, include the Equifax's Ubers, the few that we're going to talk about here today, but uh, it also includes small businesses. So moving on here, getting to the first case study, we're going to talk a little bit about Equifax. And if there is a single case that shows how a basic technical oversight can snowball into catastrophic liability, it is Equifax in 2017. So just some brief facts about it, and go ahead and get these up here. Uh, Brief facts about it. There's about 147 million people affected. So that's name, social security numbers, birth dates, addresses, in some cases, driver's license. There was a $700 million in total settlement obligations. 425 million of that came from consumer restitution. So a lot of people joined in there. But it did also have to do with 50 state attorney generals all bringing suits against the company. So there were 76 days of undetected data exfiltration here. So the attackers, they had quite free reign inside Equifax's network for about over 2 months. And why is that, you might ask? And it simply was just an expired TLS inspection certificate that prevented Equifax's own systems from detecting the exfiltration in real time. So pretty simple stuff, even back in 2017. And then last thing that kind of came out of that was the 20 years of mandated security audits. They got hit with those, which was quite costly, but thankfully they are a large company. But so moving on kind of from the legal fallout there, patching known vulnerabilities is a legal duty. That's an important thing that kind of came out of this case. And because the breach wasn't just expensive, it was honestly pretty precedent setting at the time, in the sense that the FTC, the Federal Trade Commission, framed Equifax's failure to patch as quote unquote an unfair practice, which under Section 5 of the FTC Act, for any of you legal nerds out there. The logic was pretty simple, though. They knew about the vulnerability. They knew the patch was available. They failed to apply it, and it resulted in a massive, a lot of people's personal information getting lost. But the takeaway here is that if a patch is released and you don't apply it, that's not just a technical oversight. It is indeed going to be a legal one. So monitoring blind spots or liability multipliers. So the expired TLS certificate wasn't just a technical footnote. It became more of the cornerstone of the FTC's case. And why is that? Because Equifax had systems in place that indeed could have detected the breach. And so those systems were effectively rendered useless because of a protocol that went unaddressed. So next kind of point on that is that documentation matters. That's everything. Documentation is everything. And Equifax could not produce records proving that all of their systems had been patched. They could demonstrate that they also could not demonstrate that internal controls had been enforced, which two big things. But finally, the big thing that came out of that case was that the board's accountability is discoverable. And so what that means is, in a lawsuit, after one is filed, typically goes through a process where you depose potential witnesses that you're going to try to elicit evidence from throughout the case, and also produce various documents. But so this case kind of uh, stands for also the fact that the meeting minutes of Equifax's board actually showed that the security concerns had been raised multiple times, but were either minimized or deprioritized, and the lack of follow through became kind of a key point in the shareholder lawsuits that followed. Okay, so now we're going to talk about Capital One. This is one of my favorites. So if Equifax was the cautionary tale about missing patches, Capital One is the cautionary tale about cloud misconfigurations and the consequences of ignoring known risks. So just some quick facts here: 106 million people were affected. There was an $80 million OCC fine, and OCC is the Office of Comptroller of Currency, for those of you who don't know. Um, $190 million class action settlement. The consumers sued, claiming that Capital One failed to adequately secure their personal information. Uh, and finally, the audit findings were ignored pre-breach. So that means that they had knowledge that their current measures were not sufficient, yet they just did not care. So what are the legal lessons here? Known risks is equals increased liability. Capital One, they didn't just have cloud misconfiguration; they had a documented, reported, and acknowledged cloud misconfiguration, and that distinction does matter. If your auditors are telling you that your access controls are weak and you do nothing, it's not just technical oversight anymore; it's now a governance issue. So misconfigurations are not bugs. In court, there is a big difference between a novel 0-day preventable, or sorry, novel 0-day, I guess, philanthropist hacking group taking control of your systems, as opposed to a preventable misconfiguration. So misconfigurations aren't sophisticated attacks. They're actually evidence of negligence. So they're not about the cutting edge hacking techniques. That's not what's necessarily litigated in these circumstances. Um, the next kind of big point that comes out of the Capital One case is that the public cloud does not mean shared liability. And this is actually a big thing that kind of comes up and it's a big misconception, is just because your data might be stored on AWS or Azure or Google Cloud, that doesn't necessarily mean they're responsible for securing it. Now they do have some certain basic requirements, and that is actively changing. But it's in fact a shared responsibility model that explicitly states that cloud providers handle the infrastructure typically, but you handle your own data, configurations, and access policies. And so that can create some interesting issues down the line. Finally, we got the audit trails must include remediation. So it's not enough to just find the problem. You actually have to fix it and prove that you fixed it. And this is more in the realm of regulatory enforcement, consent judgment, or consent decrees, where the government is kind of trying to ensure that the businesses are doing what they say they do. Okay. So now we're going to move on to Uber. And I included this one just because it does, in fact, have a pretty interesting situation where the CSO actually got convicted and served time in federal prison. So if Equifax was a missed patch and Capital One was about a cloud misconfiguration, Uber is about what happens when a security failure becomes a cover-up. So this case took breach response straight from the boardroom to the courtroom and ultimately to federal prison. 57 million users and drivers' personal identifiable information were exposed. over 600,000 U.S. driver's license numbers were also lost, and that was a big thing in the regulatory committee's eye. 148 million attorney general settlements. Again, all 50 state attorney generals came together in a unified settlement. And this is again that's they're not going to typically do that if it's a small company, but again because this is Uber, and because the breach wasn't just about unauthorized access, it was about unauthorized silence. And that Uber actively concealed the breach for over a year, and that delay really became the crux of the AG's argument. And also interesting in this whole scenario is that 100,000 was actually paid to attackers to keep quiet right as the breach was happening. And so Uber's security team actually paid them $100,000, labeled it a bug bounty, and ran it through, I think it was HackerOne, and the attackers all sign NDAs, which they of course abided by. And so the problem is that it wasn't a vulnerability discovered by a legitimate researcher. Obviously it was the hackers. So, and again, as I was saying, Joe Sullivan, Uber's chief CSO at the time, became actually the first security executive in a data breach case to go to jail. So what are what's the legal lessons that come from this case? And that is that delay does not equal discretion. So under the GDPR, companies have 72 hours to report a breach to regulators. And in the US, state laws vary, but typically the range is 30 to 60 days. And as I just said, Uber waited a little over a year. And that delay was treated as a deliberate attempt to obstruct regulatory oversight. So, lesson from that is that cover-ups multiply liability. So I kind of already touched on the bug bounty thing. Won't have to go back through that again, but I do want to reiterate the security leadership having personal risk, because this is the most critical takeaway of the Uber case. And the Sullivan conviction, it set a new precedent for personal accountability, in that when security executives choose concealment over disclosure, they're not just risking the company, they're also risking every one of their customers' personal, well-being. So why does this matter? So Uber wasn't just fined, they were criminally prosecuted. Okay. So now we're going to talk about the Marriott Starwood breach. It's a little bit different of a situation, but it taught the world a painful lesson, and that is that you don't just inherit assets whenever you acquire a company. You also inherit their security problems. So 339 million guests were affected. The breach began in 2014 and was discovered in 2018. 18.4 million pounds was the fine under the GDPR, I believe. Yes, so that's the UK. And then finally, the failure. What this case really stands for is the failure to detect breach post acquisition, the ongoing breach. So Marriott, wasn't just penalized for the breach itself; it was penalized for failing to discover the breach during and after the acquisition process, despite going through pretty extensive due diligence of all of Starwood's records at the time. So I guess what are the legal lessons here? And that is that M&A deals, they must include some cybersecurity due diligence. So whenever you acquire a company or sell your company, be prepared. You're not just buying assets or selling them. you're also transferring your exposure to that new company. So in this situation, if Starwood has a malware infection that persisted for years, Marriott inherits that infection along with hotels. Um, due diligence isn't just a checkbox. That was it, this was wasn't a superficial oversight. It was a systemic failure to adequately assess Starwood's cybersecurity posture. So it was more of a situation where they almost looked the other way because they really liked the property. Um, Also, you were responsible for inherited systems. Marriott tried to argue that the breach started actually before they even contemplated acquiring the company, and so they shouldn't be held fully accountable. The ICO disagreed and said once the acquisition closed, that Marriott was responsible for securing Starwood systems and including any lingering malware or backdoors. So what's the implication from this? Once you own its security risks, and ignorance is not a defense. So finally, regulatory timelines, they do matter. Marriott's argument that the breach originated pre-GDPR, again, didn't hold up. Ah, okay, so now we're going to talk about Morgan Stanley. So if Equifax was about missed patches, Capital One was about cloud misconfiguration, and Uber was about concealment. Uh, Morgan Stanley is about a different kind of negligence. It's about asset disposal. So there's no attackers, no sophisticated exploit, just poor vendor management and careless data disposal. So the kind of big points about this one. Oh, sorry about that. So no encryption. The servers and laptops, they contain sensitive customer data, but the data was stored actually in plain text and completely unencrypted. So, had it been encrypted, Morgan Stanley might have been able to claim safe harbor that exists under most data breach laws. That is a beautiful thing. But instead, the plain storage became actually a pretty critical factor, or sorry, plain text storage became a pretty critical factor in the SEC's finding that Morgan Stanley had violated their safeguards rule. So no verification, no defense. So Morgan Stanley, they tried to rely entirely on the vendor's assurances that the data wiping had been completed. However, there's no independent verification, no chain of custody documentation, no forensic spot checks. So basically, they took their word for it and weren't going to ask questions for how much it costs. But so what's the bottom line here? If you're decommissioning assets, you need to verify that the data wiping procedures are actually being followed. You know, if it costs, if you're expecting it to cost 10,000 and it cost 1,000, that's a pretty big red flag. Um, and that's kind of the lesson here from Morgan Stanley. Okay, so now we're going to talk about Anthem, and this is going to get into healthcare and HIPAA. So that's a little bit even higher of a standard and more higher safeguard requirements. But so if Morgan Stanley's breach was about failing to dispose of assets carefully, Anthem's breach was more about failing to secure the assets in the first place. And so a few quick facts here. Uh, 78 million records were breached. The OCR settlement was $16 million. And there was a $115 million class action settlement that came out of this. Um, and the two big things that really got Anthem were they were missing multi-factor authentication, and they had no enterprise-wide risk analysis. And so those two things allowed the attackers to gain access and kind of do a simple spear phishing email campaign that ended up compromising a lot of admin credentials. So, what are the legal lessons here? Is HIPAA security rule is an optional. The security rule covers entities to or requires covered entities to implement administrative and physical and technical safeguards to protect EPHI. So that's pretty standard. Hopefully, if you're in the healthcare industry, you're following that. Enterprise-wide means comprehensive. So conducting risk assessments at the department level doesn't satisfy HIPAA. The OCR instead they want comprehensive enterprise-wide analysis that maps out all the systems, all the data flows, and all the access points. OCR, that's the Office of had it up the Office of Civil Rights. Yeah, I believe yes. Oh, really? Okay. Oh, yeah. Isn't that's yeah, that's the Command F, right? Yeah. Uh, but so yes, so that's the Office of Civil Rights. I know there's a lot of acronyms here. That I'm trying to make sure that I point them out whenever they come through. Uh, oh, forgot one there. Civil liability compounds with regulatory fines. That's an important thing that kind of comes out of this as well. Is that 16 million went to the Office of Civil Rights, the OCR, and 115 million went to consumers. So it's not just one, it's not just the government that you have to worry about now. It's also plaintiffs' attorneys. So bottom line, if you're handling PHI, every system, every database, every admin account is a potential liability. Okay. So now we're going to move on and talk about some common failure points and the broad strokes legal frameworks that apply to cybersecurity specifically. I didn't necessarily include too much about privacy, even though privacy laws and cybersecurity, they typically go hand in hand. So they can also, lead to some more unintended consequences that I'm not necessarily discussing here because inherently a data breach is a breach of privacy. So failure isn't random, it's repetitive. Here are the six most common failure points that, at least at my firm, I think that we see lead to the most liability, risk, leading to more risk developing within a business. Um, okay, so we got weak access control. So this is the front door to your entire network, and yet time and time again, people leave it wide open. Anthem, there was no admin credentials compromised, and it was compromised through. I'm sorry, admin credentials were compromised through a spear phishing email. There was no multi-factor authentication, and with Uber, it was the credentials left exposed, I believe, in a private GitHub repository. Um, so that's kind of, weak access control is definitely, I would say, probably number one. Unpatched or misconfigured systems. This is the easy one that I hate to see happen, but they're hidden landmines in every network, and this is vulnerabilities that are known and documented and often left unresolved. So missing monitoring or logs. So you can't detect what you're not monitoring. Attackers had 4 years of persistent access with the Starwood Marriott breach. So, you know, their argument that they missed that in their logs or in their monitoring efforts within the organization was not persuasive, to say the least. Um, Poor incident response and delayed disclosure. This has actually gotten a lot better. I think this kind of has to do with the fact that uh, as attorneys, we're guilty as well, and our government of not advising everyone, I think, sufficiently of their responsibilities in these circumstances. But that is something really, that does hurt you and does is a big thing that you have to follow, and that's the disclosure requirements after a breach. So, a breach is always bad, but a botched breach is even worse. Um, Prime example of this would be Uber. Um, Absent governance or follow through is also another big thing. A lot of companies have policies on paper, but nowhere else. So, Capital One, the internal audits reports flagged serious security weaknesses, but remediation was non existent. So, it's not enough to be told about the problems, you have to fix them. Um, Vendor and supply chain gaps. This is something that's became pretty prominent recently, and I think that's primarily because your vendors are almost always your weakest link, and attackers know that. So Morgan Stanley is the best example of this. They relied on a pretty unqualified asset disposal vendor, and they failed to verify their data wiping and ended up paying about 155 million in regulatory fines and settlements. So why does this matter? Because most of these things are not sophisticated, highly technical things. They are basic preventable failures, and that's what you hope and ideally will stop. Um, So what are the legal or sorry, what's the bottom line is these failure points aren't typically isolated incidents either, that they result from systemic patterns. And that's the same patterns that we see breach after breach, lawsuit after lawsuits. And so really if you just need six things to think about in terms of what's going to create the most risk for my business, these six things are, I would say, 90% of 90 to 95% of the data breach cases that I've seen, at least the underlying problem. Okay. So now we're going to talk about the legal frameworks that kind of define reasonable security, and we won't spend too much time on this. Okay, so versus the GDPR, and that's kind of the one that's depending on if you're doing international business or not, but it's often viewed as the gold standard for data protection. And Article 32 of the GDPR is where the rubber meets the road, so to speak. It requires companies to implement appropriate technical and organizational measures, unquote, to protect data. And what does appropriate mean? That's, pretty broad, right? It means access controls based on user roles. And this is subsequent litigation has fleshed out what it means to be appropriate, and encryption of sensitive data at rest and in transit, regular penetration testing, and vulnerability assessments. Those are all very appropriate things to do. Okay, so HIPAA, this is kind of healthcare specific, but it's the security rule which requires safeguards, audits, audit logs, and risk analysis. Um, so this is kind of this is the baseline rule for reasonable security, and HIPAA does kind of spell it out nicely for you. But the key requirements here, they include administrative safeguards. I think I touched on this earlier, but physical safeguards, technical safeguards, and what are those? Administrative safeguards would be like risk analysis, employee training, incident response. Where's physical safeguards? That's pretty self-explanatory. Facility access controls, workstation security, whereas technical safeguards, that is unique user IDs, automatic log off, encryption, and audit controls. Those are some big things there. The SEC cyber rule is kind of new, not too new, but it essentially, if you're this mainly applies to public companies. So in that it requires them to uh, report any within 4 days, actually, of determining that the cybersecurity breach was material to their shareholders. So, um, what does this entail? It is that a lot of extensions because almost no one can figure out what happens in 4 days. But the main thing here is just to make sure that you're telling your shareholders that something material and something adverse has happened to your company, and that's basic securities law. But um, so the FTC safeguard rule is also relatively new, and it actually targets non-bank financial institutions. I know that sounds weird, but it's everything from mortgage brokers to payday lenders, and it's also not just really about protecting customer data. It kind of requires more so a documented program that can also withstand regulatory scrutiny. Um, and what is that documented program? And it includes risk assessments, multi-factor authentication, incident response plans, vendor management, all things that we've been talking about here. And finally, the 50 state breach laws. That's kind of what I've been talking about as well. Is how we're operating somewhat under a patchwork system right now, with no broad um, governmental entity who's controlling. There's no I forget they call them something in Europe. I'm losing the term right now, but essentially that control handles all things related to privacy and cybersecurity, which has resulted in 50 different states or 50 different laws in every state, um, which is hard to follow, especially if you operate your business in multiple states. But uh, the in vague terms, they usually describe reasonable security in vague terms, but they all require timely notice to affected consumers. So that's the 30 to 60 days. It's typically the time frame. Could you say it? So, yeah, I actually sorry. Yeah, I hadn't heard about that until recently. My partner's actually the one who told me about it. No, I haven't had a chance to look into it. I know that it's going to definitely that's going to be something that impacts the whole international data flow exchange thing, which I don't know why I'm blanking on. There's so yeah, yeah.
With the Cyber Resiliency Act, you'll lose your CE stamp on any products that are manufactured that don't meet it. And there are timeliness requirements that as a framework. And then the other question I had was with the risk management framework, um, which also has notification requirements.
Okay, interesting. And that's you said that's a new EU act.
EU is Cyber Resiliency Act. It was published back in 2016
Oh,
and it goes into full effect in 2027.
okay,
If you don't meet the Cyber Resiliency Act, you cannot sell products in the EU and you'll lose your CE stamp.
okay,
There's
interesting.
also with in the US, there's the risk management framework. There's notification with continuous monitoring, of which you have to notify your authorizing organization if there's any breaches.
And yeah, like I was saying kind of earlier, that's not every company that I deal with is international or does sells sells things internationally, or sorry, I guess collects data of EU citizens, which is typically seems to be the linchpin there. That's they, which is I'm sure they wish they did, but so I guess kind of get back into things. Now we're going to talk a little bit about mapping points to legal exposure. So just this is kind of a nice, helpful chart that shows, what kind of each um, failure points results in. So an unpatched system, Equifax, 700 million. No risk analysis, and think Anthem, HIPAA, um, 16 million. But okay. So access control isn't just an IT function, it's a legal requirement. And what does that mean? So it's one of the most heavily scrutinized areas in post breach investigations, and is explicitly mandated by the GDPR, HIPAA, FTC security rule, and state breach laws. Um, go ahead and get these up. So, enforcing the least privilege and role based access, the principle of least privilege, or POLP, means that every user, process, or service gets only the minimum access necessary to perform the role. And I'm sure many of you know that. But what does this mean in practice? It means that implementing role based access controls across all of your systems. So, not just your most important ones. Number two, deploy multi-factor authentication for all privileged and remote accounts. This seems pretty standard nowadays, but you'd still be surprised at the amount of people who have hybrid employees who do not have multi-factor authentication. So, they're accessing their employer's assets on unsecured Wi-Fi, a lot of times without the dual authentication. So that's a pretty big risk. But so another thing that that works a lot is the automating the offboard. Automating offboarding and access reviews. And what happens whenever someone leaves a company? That's what this is about. If your offboarding process isn't automated, you're gambling with open access. So that's if someone leaves your company, it's pretty industry standard to have that automatically remove all of their access. Dormant accounts were actually a key factor in Uber's breach. Number four was to log and monitor all admin activity. So it's not always enough to just control the access. You also need to monitor it and log it. So every administrative action, every login attempt, every failed password resets. And why is that? Because when breaches occur, regulators and plaintiffs ask for evidence that you were monitoring your critical systems. And that's did you log when admin accounts access sensitive data? Do you have records of privilege escalations? Can you produce a comprehensive log of login attempts, IP addresses, and session durations? Okay. Mitigation tactic number two is monitoring and detection that closes the gap. So this is pretty technical stuff here about information and event management. Um, so SIEM isn't just a dashboard; it's your single source of truth during post breach investigations. The key function of SIEM is normalization, so collecting logs from endpoints, firewalls, databases, cloud services, and identity providers, then correlating those logs to identify patterns. User and entity behavior analytics, UEBA. So if SIEM tells you what happened, UEBA tells you what's unusual. At least that's my understanding. Um, so this is if a payroll clerk who usually downloads 5 megabytes a month suddenly pulls 50 gigabytes of customer data over the weekend, that is going to be an outlier, and that's going to look bad if you do not catch that. So why does this matter legally? Because it speaks to foreseeability. Data loss prevention. So it is your last line of defense when SIEM and UEBA fail, and it monitors data at rest and transits and at endpoints for unauthorized transfer. Um, an example that I have here is if a user tries to upload 1 gigabyte of encrypted data to a personal Dropbox account, your DLP should flag that and block it. If not, it's not going to hold up in court, uh, and not a successful mitigation tactic. Oh, log retention and review. So that was the last one there. That's pretty self-explanatory. Review your logs and review and analyze what they say. Mitigation tactic number three, vendor and supply chain risk management. And we've talked a little bit about this throughout the entire presentation, but what does this really entail, and what are some good tactics to employ? Security assessments pre-engagement. So before you sign the contract, you know who you're dealing with, and this is where you require SOC 2 Type 2, I believe, ISO 27001 or similar security attestations from critical vendors. So if they're handling PII or PHI or financial data, you can even go further to demand recent penetration test reports, CAIQ assessments, and executive risk summaries. But it's not necessarily enough to just collect reports. You do have to act on them. Um, so another important thing here that's a really useful mitigation tactic is security clauses in contracts, and this is number one really for reducing supplier and vendor potential liabilities. If first of all, if it's not in writing, especially in Tennessee, if it's not in writing, it doesn't exist. I'm trying to speed up a little bit, but so here this means really just require vendors to maintain quote unquote industry standards, controls, which means including encryption, multi-factor authentication, regular security audits, those types of things. But another important thing that I've seen recently that I've been instructing all my clients to do is to insist on 24-hour breach notification clauses, and also indemnification for security failures and audit rights. Those three things can kind of help in the future, whenever you have a 2-3 year contract up for renewal, to be able to actually assess how they've done. Number so ongoing oversight. Really, that's just watch your contractors the entire time they're working for you. Don't just let them go and operate on their own in their own worlds. Ask what they're doing and how they're doing it. Asset disposal and data retention. We've kind of also talked about that a little bit, but it's more than just wiping a drive. It's confirming that it was wiped, and this is in fact a legal requirement now. But sorry, I lost my place there. Oh, One thing that is a nice mitigation tactic here is a certificate of destruction, which is typically where the third party has an independent auditor come in and say, yes, we've done what we say we've done, and that is a good way to kind of to de-risk yourself a little bit more if you don't want to check the work of your vendors. Oh, that's actually kind of an important one. So the shared responsibility matrix, and that's kind of what I was talking about earlier with the cloud platforms. And it's really important to clarify who is responsible for security control, whether that's going to be the vendor or your client, or whoever. Um, are you going to be responsible for data encryption, or is that going to be the vendor? Uh, who's going to manage patching? Uh, if you're breached, basically, regulators are going to ask whose job was it to do this. Okay, so mitigation tactic number 4, incident response and breach disclosure readiness. So this one's pretty self-explanatory. Pretty much just making sure you're aware of all your timelines and disclosure requirements whenever a breach actually occurs. And also, it's never going to be sufficient or excuse to say ongoing investigation, uh, in that, and use that as a excuse for why you didn't disclose what you're supposed to in the time frame allotted. Okay, 2 more mitigation tactics is the board governance and security accountability. So this kind of goes back to, courts are a lot of times going to ask, what did the board do? What were they aware of? What type of policies did they try to disseminate amongst the organization? Those types of things. So some helpful things, that tell your CEOs and CSOs to do, or if you are the CSOs to do, is quarterly cyber briefings, a board approved cyber budget. That's something new that I've seen companies, doing here, even smaller size companies. Um, Audit remediation tracking and a risk appetite statement. That's I'm a little conflicted on those because it's not entirely sure or played out in the courts whether or not that would be discoverable. So the last thing you want is to write something out and sign your name to it saying how willing you are to lose your customers' data. That's not going to look good in front of a jury. So, mitigation tactic number 6, documentation as a legal defense. And this is honestly, I think, the most important mitigation tactic that you can have in not only data breach, but literally in everything. And that is to keep records of everything. Don't throw it away ever. Even though I think that there's a 7-year requirement in Tennessee for keeping things, but um, it's kind of beside the point. Documentation is your best friend, especially in a lawsuit. So, and this, what does that include? What documentation am I talking about? That's security policies and procedures. It's not just word of mouth. You're not. It's not. It's also not emails. I've seen that before. Of you know, their policy is to email. It might, and that's typically for newer startups. But their policies are changing a lot, so they don't want to go through the trouble of putting together a corporate hand or a employee handbook with all the different policies and procedures. So they have somewhat of a constantly evolving document that's either everyone contributes to, which again, not the best thing, but it is important to document those security policies and procedures. Another important thing is security awareness training logs. So it's not enough to just say that you told all your employees how to do and what to look out for. You need to. It seems kind of ridiculous and hand holding, but have them actually uh, sign something saying I attended this talk and I have learned what I need to learn. Incident response, run books, and debriefs. Okay. So what is it's really a post-mortem report or a debrief that outlines the timeline, actions taken, and lessons learned from a security incident. So I'm always hesitant to put this kind of stuff in writing as well, but the bigger institutions, this pretty standard um, documenting procedures. Okay. Well, GRC systems and board reporting. That's it's governance. GRC is governance, risk, and compliance, and they're platforms that track security initiatives, audit findings, and risk mitigation efforts. Um, but why is it important? Is the 2023 SEC's cybersecurity rule explicitly requires disclosure of board oversight of cybersecurity risks.
With security policies, would you recommend having a hard copy of version control?
Yeah, I think that'd be pretty reasonable. I guess it's also pretty important to make sure that everyone has access to the most up to date version, and that if you do have version control, that you're pretty well, that you're, I guess, without error in updating that version control.
The question was security policies. Would you have a hard copy with version control? Just to repeat the question.
Oh,
Anybody else?
okay, no, you're fine. But yes, so that I think is a good idea and acceptable. A lot of people do that. Version 1.0, 1.1, 1.2. But real quick here, just going to get into these bonus materials, and this is actually, I think, pretty helpful here, considering the prominency of cyber insurance these days. So why can't you just insure it away? The limits of cyber insurance, and that is Um, so there's coverage limits in almost every policy, and they also almost always exclude coverage for regulatory fines or imposed due to negligence or willful misconduct. So, you think that it doesn't give you a free pass to have no security in place. Essentially, that is a big point there. Um, but the plaintiff's dilemma, difficulties in proving data breach damages. This is something interesting that I've recently seen, and that is it's pretty hard. So as these lawsuits are getting to their final stages, it's been pretty hard for plaintiffs to prove that you've actually suffered damages. In that, like I was saying, Equifax breach, they lost almost half of the United States population's data. So who's to say that someone on the dark web has not already got someone's data from a subsequent breach? And that's kind of the argument that defense attorneys are making right now to limit companies' liabilities. And then obviously, there's ways to counter that, but and this is kind of the last thing here. We've got a legal liability landmine checklist. And this is just something kind of useful to think through whenever you're making your own policies. Something that I try to a general guide that I try to give my clients at least. Oh, forgot governance. We'll see if this works. This is just a nice little fun poll. So it's choose the top area where you feel your organization is most exposed. So feel free to send in a response or just yell it out.
Is all of the above an option?
Right. Oh, let's see.
All right, I think that is all the time that we've got.
Yes, that's that was the last slide. Or,
Yeah.
There.
Excellent.
There we go.
All right, big round of applause.
Thank you, guys.